In this video, we will be discussing what your loved one might expect at their initial court appearance after being arrested. Please note that their experience may differ significantly from what is stated in this video for any number of reasons. Our goal is to familiarize you with the overall process as it exists in most cases, as well as introduce you to some important terms. Sometimes individuals charged with more minor crimes may be released without arrest and given criminal summonses to appear in court on a specified date. If, however, your loved one is arrested, you will likely want to know what happens next. In most cases, when someone is arrested, they will be taken to the police station, processed, and put in a holding cell. They may be transported by the arresting police agency to another police agency if that agency is responsible for the investigation or has already issued an arrest warrant. In other words, if your loved one is stopped by a Newcastle County police officer and she discovers that your loved one has an active warrant for their arrest on new charges, which is also called a hard warrant, out of Delaware State Police Troop 6's jurisdiction, your loved one may then be transported to Troop 6 headquarters. Police may question your loved one, or they may put them before the judge immediately after completing processing. They will fill out a defendant history, also known as a pedigree sheet, with basic information such as their name, date of birth, address, phone number, and employment information. Once they have filled this form out, your loved one will appear in front of a justice of the peace, also called a magistrate, for an arraignment or presentment. You will hear both of these terms used, but they are not interchangeable. If the Justice of the Peace Court has exclusive jurisdiction, or concurrent jurisdiction with the Court of Common Pleas over all of the criminal charges involved, then it is an arraignment. Having jurisdiction means that that particular court may hear that case through trial to sentencing. The Justice of the Peace Court and the Court of Common Pleas may only hear cases involving misdemeanors and violations. They cannot hear felony cases. If it is an arraignment, your loved one may have to choose whether they wish to have their misdemeanor case heard at a later date in the Justice of the Peace Court, or whether they wish to transfer it to the Court of Common Pleas. More on this later. If the initial court appearance is a presentment, the court reading your loved one their charges, the Justice of the Peace Court, must send the case to another court to be heard because it does not have jurisdiction over those charges. The judge will explain to your loved one which court their case will be going to, so they know what to expect. Except for minor traffic infractions, anyone under the age of 18 will have their case transferred to family court. In serious felony cases, family court may hold a special hearing, called a non-amenability hearing, to have the juvenile's case sent to superior court. This is a good time to discuss the difference between misdemeanors and felonies. A misdemeanor is a crime less serious than a felony and more serious than a violation. Examples of misdemeanors are offensive touching, assault third degree, terroristic threatening, resisting arrest, shoplifting and other thefts under $1,000, harassment, and disorderly conduct. From the most to least serious, misdemeanors can be Class A, Class B, or unclassified. If your loved one is an adult charged with a misdemeanor where a family member or domestic partner or any unrelated juvenile is the alleged victim, their case will automatically be transferred to family court. If your loved one is an adult charged with a misdemeanor that does not involve a family member or domestic partner or any unrelated juvenile, in many cases they will have the right to choose whether to have their case remain in the Justice of the Peace Court or have it transferred to the Court of Common Pleas, which is the next higher court in the state court hierarchy. If the case is eligible to be heard by either court, the magistrate will explain the differences between the two courts so that your loved one may make an informed decision. A couple of the main differences worth noting are that, in the Justice of the Peace Court, judges are not required to be attorneys. All judges in the Court of Common Pleas, however, are attorneys. Also, public defenders do not appear in the Justice of the Peace Court, but are available in the Court of Common Pleas and the other higher courts to represent individuals who are without sufficient financial means to hire their own attorney. Whether your loved one will qualify for representation by a public defender will be determined by the Office of Defense Services. And now some information about felony charges. A felony is a crime of a more serious nature than misdemeanors and violations. Like misdemeanors, however, all felonies are assigned a class. Class G felonies, like theft of a motor vehicle, are considered the least serious felonies, and Class A felonies are the most serious. Examples of Class A felonies are murder and rape in the first degree. Even the least serious felonies carry potential jail sentences. Crimes involving significant injury to a person, as well as nearly all firearms offenses, are felonies. There are many other crimes which fit under the definition of felony. The Superior Court is the court of general jurisdiction for the state of Delaware. This means that they have authority to hear cases of all kinds. After your loved one's presentment on felony charges in the Justice of the Peace Court, they will automatically be scheduled for a preliminary hearing in the Court of Common Pleas. At a preliminary hearing, the state must present evidence to the court to establish that sufficient probable cause exists to hold the defendant for trial. To establish probable cause, the court must have a reasonable belief that a crime has been committed and that your loved one committed the offense. Probable cause is a relatively low bar and is no indication that an individual will later be found guilty, as the proof standard at trial is much higher. Each county has one Justice of the Peace Court, which is open 24 hours a day, 365 days a year. Your loved one may see the magistrate as soon as several minutes after their arrest or up to several hours after, depending on the situation. In most cases, your loved one will be seeing the magistrate by video from the police station. However, in some cases, they may be brought directly from the location of arrest to the court. The magistrate will begin the proceeding by asking for basic information from your loved one, including their name and date of birth. They may also ask for your loved one's address. The magistrate will advise your loved one of their right to remain silent and their right to an attorney. The magistrate will then read each charge and provide some basic details about the offense based on the arrest warrant. For instance, what your loved one allegedly did, which was criminal in nature, when and where they allegedly did it, and potentially who the alleged victims were. The magistrate will also advise your loved one of the level of the crime, whether it is a violation, a misdemeanor, or a felony, and what class of misdemeanor or felony it is. Along with this, they will advise your loved one of the potential penalties they face if convicted, including the range of any potential jail sentence. The magistrate will go through each charge in the same fashion. They will set bail and any appropriate conditions. Look for our video on bail for more information on this.